copyright. So let's talk copyright. This I think is extremely important for video game developers, because copyright is most of what you're doing as a developer is copyrightable, and it's a lot of your value for your company is going to be there. So in video games, one of the big questions is what is actually protectable by copyright in your video game. There's 3 limiting doctrines to what's protectable for copyright. There's something called the idea-expression dichotomy that you need to be familiar with, and this is the sort of crux of a lot of cases that come up in video games. Something called the merger doctrine, and something called, and I'm not French, and I don't do a French accent, but it's called savoir-faire, I think. That's a French term, but we'll get to that in a second. So idea versus expression. This is something you absolutely have to know if you're doing anything copyright related. From the actual copyright law, it states that in no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, on and on. Those may sound familiar to you because those are the things that patent is protecting, right? So if you want to protect your ideas and your processes and sort of mechanics behind the game, those are the things that are going to be protected by patents rather than copyrights. Examples of ideas that are unprotectable in video games are your game mechanics, right? Like how your first-person shooting game sort of works behind the scenes. You're a guy running and you're looking what the camera view is and all of that stuff. The rules of the game and the concepts behind the game are things that are not protectable by copyright. But the expression of those ideas is what is protectable. So in a video game, your expression are things like your art assets, your character designs, the text that's in your game, the dialogue that people are speaking, the music, and things like that, the story of the game. Those are all generally protectable by copyright, and that's what you need to worry about. The other 2 limiting doctrines are something called the merger doctrine. So the court has said, in some instances, there comes a point when an author's expression becomes indistinguishable from the idea that they seek to convey, such that the 2 merge. So basically, when there's only one or maybe a couple ways to express an idea in a game, it kind of merges with the idea and it becomes unprotectable. So let's say, I think this came up in a case involving the game Asteroids. If you remember this, it was just like a little triangle that you would spin around and shoot a bunch of meteors or asteroids that were coming in. And basically, there's only so many ways to express what they were trying to do in this game. I mean, it was like these asteroids that were just basically an outline of an asteroid. So in that point, it sort of merges with the idea, and your expression is not really protectable. So it isn't, and especially now with modern video games, there's so many ways to express a lot of the ideas. It's a little bit rare. Savoir-faire, on the other hand, these are expressions that are common in a particular genre, and they're not protectable. So let's say you have a genre of games, I don't know, like a fantasy-type game. Oops, excuse me. Uh-oh. Okay, fantasy-type game that's going to involve knights and dragons and things like that. You're not going to be able to protect those sort of stock characters and stock things that are the situations that are staples to that genre. Those are things that you're not going to be able to do. And maybe even things like, layout elements like a scope on a sniper rifle or something like that. There's only so far you can take that in the expression, and it's sort of... it's just common to the genre, and you can't get any protection about that. So we're going to go through some of the earlier cases in video games. There's one in particular that involved a game called Street Fighter II, which was very popular in the 90s by a company called Capcom. A company called Data East came out with a game called Fighter's History. And the characters, Street Fighter II had karate guys and characters like an army guy and various... fighting game characters. If you're familiar with the game, you'll know them. Fighter's History came out, and it had basically the same exact characters, just sort of drawn in a different way, right? They were doing the same moves, same flips, and same kicks and things like that. So the court found that even though they blatantly had copied this game, right, and all the moves and everything like that, there was nothing protectable that they found in the game that was actually copied. So the protectable elements, or the elements that Capcom had used in Street Fighter II, were basically, they said they were stock characters, and the various kicks are just real martial arts moves, stock moves that have been used. Even the fireball, characters will shoot fireballs out of their hands, right? And Capcom argued that these fireballs were an expression of the idea of shooting a fireball, and they should be protected. But the court argued back and said, look, there's the fireball itself is the idea, and the particular expression, unless it was directly copied, and I think the fireball maybe in Fighter's history was a different color than the original fireball in Street Fighter 2. Unless there was an actual direct copying, there could be no protection there. So that's sort of how things were for video games for a long time, until recently. There have been a few cases that have sort of thrown a wrench into this and maybe moved for courts to protect a little bit more than just the expression of the concepts. So there's a company, there's a game called Tetris. It's one of the most popular games ever. So if you know the games industry, you should know Tetris. A company called Zeo Interactive actually did a clone for smartphones of Tetris. Essentially, if you saw the two together, you would think that they were the exact same game. There's some slight differences in the art. They got sued by Tetris Holdings, who owns the rights to Tetris in Texas, and the court found that they were infringing because, I mean, it was an exact clone. But the court had some language in there that maybe gave rise to the idea that maybe there were protectable elements that were inside of the game that were beyond just the artwork and things like that. That the actual game and the look and feel of the gameplay and how the game mechanics interacted with the art, that could be protectable. So this was sort of picked up by another case. A Washington court adjudicated Spry Fox v. Law Apps, which involved a game by Spry Fox called Triple Town, where essentially you're running this little town and you're taking things like bushes, and when you match 3 bushes together, it upgrades to a tree, and then you match 3 trees together and they upgrade to a house or something. And it had this hierarchy of objects. Now, Law Labs created a game called Yeti Town, which was basically the exact same game. So all the underlying stuff was the same, except all the artwork and the things that you would see were all totally different. So they changed it to a winter theme with a Yeti instead of a bear and things like that. So while all the game mechanics were exactly the same, all the stuff that you would normally think was protectable was totally different. However, the court it allowed it to survive a motion to dismiss because it found that maybe some of these elements, and the specific quote is, the gameplay element of object hierarchy that progressed from grass to bushes to trees to houses and beyond is protectable. So they found that this thing that is just a rule of the game or a mechanic of the game is actually protectable, or could be protectable by copyright. So it survived the motion to dismiss, which actually led to a bunch of other complaints being filed, sort of using this logic of the object hierarchy or some sort of game mechanic behind it. So there was a few cases, one involving a mobile game called Game of War, one Glue Mobile v. Hothead, which involved a deer hunting game where it was essentially a clone, but you were hunting humans instead of deer. And Wizards of the Coast is another plaintiff. They created the Magic the Gathering game, which is hugely popular. And then there was another company called Cryptozoic who ran a Kickstarter crowdfunding campaign, raised millions of dollars to do a game that had a lot of similar mechanics to Magic the Gathering. So Wizards of the Coast sued them for copyright infringement, even specifically calling out specific game mechanics as copyright infringement, which normally would have been unheard of. It's generally unprotectable. A lot of these cases resulted in settlements, mostly by winning. They're confidential, but the plaintiffs were obviously winning because then the defendants would be taken down off of the app stores. Until recently, there was a decision. Well, there was a case involving card games, Da Vinci Editrice v. Zico Games, involving a card game called Bang, which is sort of a Wild West card game where you're going after other people, and each player has a role that's given on their card. Now, a company in China basically created a clone of this game called Legend of the Three Kingdoms, where all the mechanics were essentially exactly the same, but they changed all the text on the cards, and they changed the artwork, changed the character names, things like that, but basically released a clone with a re-theming to make it based on Chinese history. The people that make Bang sued Zico in Texas, and when Zico moved to, when Zico moved to dismiss the case, on the grounds that this was all unprotectable game mechanics. The motion to dismiss, or the case survived, and in the opinion there, the court kind of gave an idea that all of the various character roles and things that would normally be just unprotectable rules and mechanics, all of that kind of gave rise to this new creative expression, right, of the gameplay between the characters and things like that. So it was a little perplexing, but as the case went on, and finally this year in April 2016, the case was finally decided and actually went the opposite way. So the court limited copyright protection in game mechanics to something that's actually very much higher than what's in this game. Certain games, they said, can have a progression of events and a roster of developed characters that make the game expressive, just as the progression of a book or movie plot can be expressive, even when the basic elements are common. So they likened this card game, and probably a lot of other games, to a game, the rules of basketball, where you can't copyright the rules of basketball. But if you have something like a game like The Legend of Zelda, which involves a character going through a number of plot progressions and levels and things like that, that's giving rise to copyright protection. And that's sort of in line with traditional views of how idea and expression work. So, you know, it's sort of a weird time now where you have some courts that are saying that a lot of these game mechanics are giving rise to copyrightable material, whereas this recent decision has sort of brought things back. So it's an interesting time in video games, and while that's a card game, they do talk about video games and what's protectable. So I would definitely recommend anyone that's interested in this type of copyright law to read this Da Vinci v. Zico Games opinion, because it gives a great overview of the copyright law and how it applies to games. So as I mentioned before, one of the important things to do for your clients is to register their video game copyrights. Generally, you want to register either within 90 days of the publication of the game, or it has to be done prior to any kind of infringement. So, I mean, the best practice is to register it on the day it's published, right? As soon as you start making it available for sale, you should be filing your copyright registration that day. The reason to do this is because you can take advantage of what's called statutory damages, and also be able to get attorney's fees if you have to sue an infringer for copyright infringement. Statutory damages can be up to $150,000 per incident if there's willful infringement. So that helps, and it helps you not have to actually prove actual damages, especially for a lot of smaller developers who aren't going to be making tons of money off their game. Getting the statutory damages is sometimes much better than having to prove your actual damages. There's a thing in the game industry called early access, where basically a developer will put a game out for download and for purchase before the game's actually finished. So it's sort of in a beta version, and the platform Steam does this a lot. It allows you to put the game out early. In those situations, it may be appropriate to do 2 copyright registrations. So when you publish that early access version, you may want to file a copyright on that, and then later on, when the final version is registered, file another copyright registration based on that earlier registration. Okay, and so what do you actually register it as? This is a question that comes up a lot because there is no video game type or category for copyright registration, so you sort of have to work within the pre-video game system, which allows, and the two most prominent ones are literary works or audiovisual works. Now, the Copyright Office says to basically look at the game and see whichever is more prominent, either the source code and the written material in the game, or the audiovisual material. So if the more common or more prominent material is the music and the graphics and things like that, and it's probably more common now to do it as an audiovisual work. Generally, you can do a single registration. You don't have to do, some lawyers recommend doing a literary work and an audiovisual work registration. I don't think that's necessary, and I think the Copyright Office themselves have said that one registration is sufficient. I think even in the Tripletown case that we talked about before, they only did one registration as an audiovisual work. And you need to prepare the proper specimens for delivery to the Copyright Office, the Library of Congress. So generally, you're going to have the first 10 pages and the last 10 pages of the source code of the game. Sometimes there are trade secrets in there, just like we talked about, so things that the developer doesn't want to get out, and how they specifically program things, that may be included in the first or last 10 pages. So you can redact them. That's okay, as long as the entire thing isn't redacted. You're going to include several screenshots of the game, probably 5 to 10 screenshots representative of what the gameplay looks like and what the game looks like. Also, if you can upload a video, maybe have the developer create a 1-minute video of gameplay that's sort of representative of what the game looks like. And you can upload MP4 files to the Copyright Office when you're filing the registration. If the game is released on physical media, and like we looked at before, 56% of sales are on just digital only. A lot of games don't even come out on any kind of physical media. But if you're releasing something for PlayStation, let's say, and you have an actual Blu-ray disc with the game on it, that would be the best version to send in to the Copyright Office. They want to keep a specimen in the Library of Congress for it.